Test 1, 2, test 1, 2. It's a Sunday, October 4th, and this week would be the week that you need to be finishing up the first exam. In all honesty, there may be some difficulty with some of the questions you'll encounter, but on the other hand, it's no more or less than some true-false questions. So I don't anticipate anybody who's involved in the course with any degree of commitment should have any difficulty in getting the exam done. What I want to do in this video is talk a little bit about a case that I've linked to, or if you will, a decision I linked to for you to read. It's I think a 1975 decision from the New York Court of Appeals, the highest court in New York. The name of the case is People versus Strong. Each state has a different way, or better said, there's different ways that states refer to themselves in prosecution of criminal cases. In New York State, the state is known as the people of the state of New York. I know when I used to do some criminal defense work, I always felt uncomfortable with that. Quite honestly, it had an authoritarian ring to me, and I used to refer to the other side as the prosecutor, or as in federal court, the phrase I liked was the government. I wanted to make certain that if there was a jury there, that the jury knew that it was me and my client facing the great array of forces that only the government can bring to bear when it seeks to prosecute an individual, rather than have the jury believe that they were part of the prosecution because they, like the prosecution, were the people of the state of New York. In any event, there's a procedural event that gives rise to the appeals in the Strong case, and I want to describe that event. Otherwise, I don't think the case or the decision will have as much meaning to you. So in this video, I'm really talking more about criminal procedure than anything else. And as we then go forward, we'll use the Strong case to anchor analysis of principles of criminal liability. The first is procedural event that I want to talk about. And the event occurs after the parties, the prosecutor and the defense, tell the judge that we don't have any more evidence to bring forward. And if we're looking at the jury, what the jury is going to experience next is that the attorneys will deliver their closing statements, and then the judge will give the jury instructions about the law, how they should go about analyzing the different legal requirements to reach a verdict. But before the jury receives the summations and before the jury receives the judge's instructions about the law, the judge and the prosecutor and the defense attorney will have a conference outside of the presence of the jury. The jury won't be there, in other words. Sometimes this event is called a charging conference. And at that conference, the judge will iron out different positions that the parties have offered regarding what should be in the judge's charge. And a key part of that conference is what we could refer to as a request to charge a lesser included offense. In other words, the judge will turn to the prosecutor and the judge will turn to the defense attorney and ask each one of them, do you want me to charge down, or charge a lesser included offense? What is a lesser included offense? It's a offense that's not as serious as the one that's charged, and there's enough evidence for a reasonable person to believe that the charged offense may not have been established, but that the lesser included offense might have been established. Now, you might ask, why in the world would the defense want a judge to charge down to a lesser included offense? And the answer, quite frankly, is it's a way to cut your losses. And this is what happened in the Strong case. If you've read the decision, you'll realize that there's no way, it seems to me, that any sane defense attorney would ever believe that a jury would render a verdict of not guilty, that the jury would be bringing in a verdict of guilty. So now the question is, from the defense perspective, is there a way to have a lesser included offense before the jury so that the argument could be made to the jury that the prosecution didn't establish the offense that's charged, but if you look at the evidence, it's probably reasonable to believe that the prosecution did establish the lesser included offense. And if the jury buys that argument, as in the Strong case, I believe that you would go from a C felony, which at the time carried up to 15 years of imprisonment, to a felony at the lowest level, an E felony, which I believe at the time carried a maximum of 4 years. So whether the defendant would appreciate that or not, a verdict of guilty on a lesser offense, which in this case would have been criminally negligent homicide because he was charged with manslaughter as a reckless form of manslaughter, you would have cut about 11 years of possible imprisonment off the defendant's future, which most lawyers would think isn't a bad day in court. Particularly whereas here, you'd have to believe that a jury isn't going to cut a guy loose who did the rather outrageous things that Strong did when he killed this guy. So in Strong, at that charging conference, the defense asked the judge to give the jury the alternative of finding the defendant not guilty of the reckless homicide charge and guilty only of the lesser included offense of criminally negligent homicide. Now, when that application or request for a charge down is given to the judge, as you'll see when, or you have seen in reading the decision, the judge must grant the request if a reasonable view of the evidence would permit someone to analyze the evidence and say, well, he's not guilty of what he was charged with, but he is guilty of this lesser offense. In the Strong case, however, the trial court ruled that there's no reasonable view of the evidence that this defendant didn't commit reckless homicide, but only criminally negligent homicide. And I believe the essence of the judge's take on that was no reasonable view of the evidence would support the belief that the defendant did not know that his conduct created an unreasonable risk of death to the follower who Strong killed when he put a hatchet into him and stabbed him in the chest with a knife. So the charge down request is denied. The jury then is given only one choice. Is he Strong guilty of reckless homicide, a form of manslaughter, or is he not guilty? Not surprisingly, the jury said when it came in with its verdict, he's guilty. So now the defendant exercises his right to appeal, and eventually the appeal, after being unsuccessful at the lower court, the appellate division of the state Supreme Court, reaches the New York Court of Appeals. And the question that the New York Court of Appeals decided wasn't whether the defendant was guilty or not. It also didn't decide what it believed to be the best outcome based on the evidence or the most reasonable outcome, but only this question: could a jury have viewed the evidence of what the defendant did, and could the jury have concluded that the defendant, while acting in a manner that was grossly or extremely negligent, didn't perceive the risk that he would kill this guy, as opposed to the reckless form of homicide theory that he had to know that death would result. So it's interesting how the Court of Appeals determines this decision, and please, or this issue. And please note that the defendant prevails on the appeal does not mean that he's not guilty. It simply means that his conviction is overturned, and the case is sent back to the trial court for a new trial. So this video, I hope, then gives you some insight into the procedural question and makes your reading of the Strong case